Arbitration versus litigation. Which is the better approach to dispute resolution? A date for litigation?
Okay. In 4 minutes or less, what I
can't do it.
what I would tell you with the constraints of time, the biggest thing for me, two things actually. The top two things are probably the top 5 or 10 things. With litigation, I would suggest to you, and it's probably a minority position, but I would suggest to you with litigation, you save money, you save time, and you have a better outcome. And let me explain that, because I do think it's a minority position. I think through experience, my experience, that parties are more concerned about going to court than going to arbitration. Some of the advantages of arbitration really are disadvantages in terms of cost and outcome. I think most litigants, most parties to a contract that have a dispute, feel that because of the flexibility and the convenience and some level of predictability, they push a case all the way to arbitration where they won't at trial. Cases that go through the trial process, I think, are also better prepared because you have a sense of the value of the case, you have a sense of the merits, you've taken depositions, you've maybe filed motions. People have thought about the case more than they have for arbitration. Arbitration, I think, too often leads to people saying, I'm gonna show up, I'm gonna take a roll of the dice. I think scheduling with arbitration also can lead to significant delays. The parties are in control more than they are with the court. The court has harder deadlines. People end up extending things with arbitration too often. So I think some of the perceived advantages of arbitration are actually disadvantages in terms of getting to settlement. Settlement is an outcome controlled by the client. And ultimately, if you're saving time on both preparing for evidentiary hearings, presenting those evidentiary hearings, and then potentially having post-hearing memos, whether it be arbitration or litigation, your money as a client is in the prep for trial or arbitration, actually presenting, and the after. And if you're incentivized by fear is a great motivator. If you're incentivized by wanting to avoid the courthouse steps, then I think litigation is the way to go.
Okay.
Joe for arbitration.
So now we have a debate. I couldn't disagree more with what David just said. I'm going to give you. I was going to start by saying Dave got the tough end of the stick, but if that's, I think we just flat out disagree. I, draft and review contracts for my clients daily and write contracts for them on a regular basis. And never, ever would I suggest that you sign a contract that does not contain arbitration for, ironically, some of the reasons Dave talked about. It is faster. It is much faster than litigation. If you file a case in Rhode Island Superior Court today in Providence County, I'll see you in 4 years for trial. In 4 years, no one cares anymore. You've forgotten, the money's not that important, people go out of business, witnesses disappear. It's an endless black hole for your money and time. Massachusetts, not much better. They have a stricter, tighter control on it, but you file in Middlesex, it says 2 years, 3 or 4, because the judges aren't available. I had a county where a judge wasn't available for 2 years. There was no judge available. That's what they told us, even though we should have been trying our case. It is an endless black hole for money. You have depositions, interrogatories, production of documents that go on and are pretty much endless. Courts, a lot of latitude for that. A lot of money is spent there. Arbitration, it's fast. It's cheaper because there's no depositions and there's no discovery. And it is much faster. I'm right now involved in an arbitration, about $1.5 million. We filed the demand in November. We've already had 3 days of hearing. We'll have 3 days in April. We will write briefs probably May, and it'll be done. That case will be resolved in July. I don't know how it will go, but it'll be done. If I filed in state court, it would be 2021, 2022 before it even got reached to trial. I think there is no better avenue than arbitration, particularly in construction disputes. You want someone who's an experienced construction attorney, a general contractor, an architect hearing the case who understands it. Judges and juries don't want these cases. They want CDS, they want all that sexy stuff and forensics, you go in and say construction, the jury goes to sleep. The judges hate these cases. They're not interesting. They don't really care. I actually had a juror go to sleep on me once and made eye contact with
More
the
than
judge.
once.
Literally fell asleep in the box. The judge had it. It is, arbitration is the way to go.
Chris, a comment on mediation.
Yes, so you can mediate any dispute, whether it's going to arbitration or litigation. Frankly, trial lawyers are going out of vogue anymore because nobody wants to try cases. This goes to Joe's point, I have to agree with him. Arbitration is, I think, preferable. And litigation is just so expensive that everybody is settling any case of any value. So literally, and that's probably a good thing, and they're settling them through mediation. So you ought never to, mediation is like chicken soup for a cold. It may not help, but it may make you feel better. And maybe it'll help. So I recommend it.
Any questions on arbitration, litigation, or mediation?
And can I just say one thing about mediation quickly? Chris is exactly right. Mediation is non-binding. You go before someone who hears both sides and he or she tries to work it out, moves between you. The good thing about mediation is he or she brings you into the room and says, this is what's wrong with your case. And a lot of times the clients need to hear that. You need to hear that it's not a slam dunk. And then they do the same in the other room. And it starts to make people aware that nothing is a slam dunk in any dispute.
One other thing, with regard to mediation, I would suggest that mediation is more effective prior to litigation for a lot of the same reasons I said before. It comes at a different time. The parties are more incentivized. Typically, the mediation requirement prior to arbitration is at a stage where the parties are not focused on the evidence. It is before it has gone to arbitration, before they have incurred significant expenses. You can do mediation at any time, whether it's arbitration or litigation, but I do think that mediation prior to litigation, the parties are more incentivized and more concerned